Master Treasurer, good evening. Welcome everyone to this, the third in a series of public talks sponsored by the Selden Society and the Four Inns of Court in London. My name is Donald Tryon and I am the president of the Selden Society. It's my pleasure to be moderating this talk this evening. The Selden Society was not founded for the study of John Selden. It recognizes, of course, his greatness as a lawyer, a politician, a philosopher, and a polymath who lived in the early 17th century. But it was merely named after him to honor his name. This series of annual public talks is aimed at demonstrating the relevance of the study of legal history to the challenges of today. In a land where no single document encompasses our Constitution, legal historians are in many ways the guardians of our Constitution and thus our liberties. As Selden himself put it, the purpose of legal history is bare and sterile if it is merely to study antiquity itself. It is to be, as he put it, exceedingly busy after nothing. On the other hand, he thought that the proper study of history gives a necessary light to the present, and history itself is important so that we understand the law, the Constitution, and indeed humanity generally. Our hosts this evening are the Honourable Society of the Middle Temple. We're in the magnificent surroundings of the Middle Temple Hall. I mention that for the benefit of those who join us online. Most of you who have joined us in hall will have worked that out already. Online, we have at least as many people as are in hall. We have people from 3 continents and more than 10 countries. This is a development which has come about since COVID. And we now have an outreach to the world that is interested in the common law and the values of the common law. So much interest in this talk is in fact hardly surprising, given the significance of the topic and the distinction of our speaker. Our speaker is the Right Honourable Lord Judge, former Lord Chief Justice of England and Wales, a former Treasurer of the Middle Temple, and past President of the Selden Society. He is currently the convener of the crossbenchers, that is the non-affiliated members of the House of Lords, and he is a distinguished scholar and an accessible writer. Lord Judge has written extensively on various aspects of law, the Constitution, history and legal history, and his talk tonight can hardly be more topical or relevant. 1662, the King's prerogative; 2022, the Prime Minister's prerogative. I hope somewhere John Selden himself will be among those listening remotely to what Lord Judge has to tell us. Lord Judge.
Thank you so much. Thank you. Thank you, Master Treasurer, President. When did the trouble start? It certainly didn't help things in 1609 when King James told Parliament that, I'm quoting, the state of monarchy, I think John Selden may be listening, the state of monarchy is the supremest thing on earth, modestly adding that all the attributes of God agreed in the person of the king. I don't think any of our prime ministers have made that claim in public, though possibly one or two may have thought it privately. The 1609 Parliament included something like 100 lawyers from the four Inns of Court among its members, many troubled by the new Scottish king's approach, and it was particularly unwise for him to prove his ignorance of the common law by claiming no law could be more favourable and advantageous for a king and extend further his prerogative. It was even more unwise for him to fail to recognize the importance of the response, which in 1610 took the form of the Petition of Grievances. I can just digress. I do like the adjective used by one of its proponents, James Whitelock, who was from this place, who spoke of home-born rights. Home-born rights. That is a fair description, one tends to overlook, of the European Convention. Anyway, back to the petition. It was a measured complaint against rule by proclamations, which tended, I'm quoting, to alter some parts of the law, and it expressed concerns that proclamations would, I'm quoting again, by degrees grow up and increase to the strength and nature of laws. Ladies and gentlemen, what they perceived as the menace of proclamations is now disguised by its modern manifestation, statutory instruments. But first to the title of this lecture. By December 1621, the troublesome relationship between James I and the House of Commons boiled over. So, true loyally fashion, they drew up a declaration of grievances. The king was outraged. The Commons offered a second petition, reasserting their rights, respectfully inviting the king to take away the doubts and scruples your Majesty's late letter to our Speaker hath wrought upon us. The king's answer was, your asserted rights are no more than whatever I am prepared to tolerate. So the Commons produced a protestation. It was entered on the Commons journals. James adjourned Parliament. A few days into the new year, he went to Parliament. He demanded to see the journal. He read the entry. He literally tore it out of the book to be erased out of all memorials and utterly to be annihilated. Parliament was dissolved because the Commons had taken inordinate liberties with our high prerogative. Sir Edward Coke, former Lord Chief Justice, was locked up in the Tower where he remained for 7 months, regretting most of all the absence of his law books. Locking your opponents up was one of those things that the Stuarts were inclined to do. It's an unpleasant habit, isn't it? Later on, our own John Selden was locked up and deprived of his liberty more than once, and finally for 5 years. We were now on a path, not an inevitable path. The history tells us it was, but it wasn't, but the path which ultimately led to the Civil War and the execution of the king. Reflecting that dreadful turmoil and chaos, Thomas Hobbes produced the Leviathan, postulating concentrated power. I authorize and give up my right of governing myself to this man on condition that thou give up thy right to him and authorize all his actions in like manner, to the end that he may use the strength and means of them all as he shall think expedient. I was brought up to regard that philosophy of concentrated power, effectively unconstrained political power, with distaste, and I still do, passionately, just as much as if I were a 17-year-old idealist. Within another 40 years, a new King James was driven out of his kingdom. That dramatic event required its philosophical justification, and in his treatise on civil government, John Locke provided it. Political society must establish legislative power, but the legislature violates its sacred trust, his words, if among other things it ignores the principle that it must nor can transfer the power of making laws to anybody else. All was well now. We would never again be governed by the king. We'd be governed by the king in Parliament. In those days, to start with the king, comma, in Parliament, the king tolerating Parliament as he thought useful, but now our constitutional settlement was the king in Parliament. Stop. Think of the difference. Recognize the difference between the king, in Parliament and the king in Parliament. The punctuation marks are absolutely critical. King in Parliament with hyphens is equilibrium. Now jump 400 years to today, 2022. That equilibrium of king in Parliament has become a mythical constitutional fiction. The Lords has negligible power, although still some influence. The head of state, the king, is a constitutional monarch who, notwithstanding his lifetime's concerns for the issues, has accepted advice not to participate at COP27. Constitutional power is vested virtually exclusively in the Commons. And although that is the principle, in reality, my thesis is that the exercise of power resides in number 10 Downing Street, which nowadays, of course, exercises significant oversight over all the departments of state. Of course, it is a comfort. Modern prime ministers cannot lock up their opponents. And it's another comfort that they can't remain in office for life. But despite those very important distinctions, I venture to suggest that the true description of where actual power rests is the Prime Minister in the Commons. And at the end of this, you can work out for yourselves where the punctuation, comma, or hyphens should be. For the purposes of today's talk, I chose 2022 because the Dissolution and Calling of Parliament Act 2022 was expressly designed to restore the royal prerogative. The Prime Minister advises the monarch that Parliament should be dissolved, and the monarch has no choice. There was a suggestion in 1950 that there were 3 situations identified in a letter to the Times signed with the nom de plume Senex, which suggests that on 3 separate occasions or instances, the monarch could refuse the application. I personally don't think it runs today. I think it's significant that the writer of the letter, who was the King's private secretary, signed that letter Senex. Now, for those of you who are judges who don't do the Latin, that means old man. I learned that, I was reminded of that by my granddaughter who's sitting here in the front row when she learned what the meaning of Senex was, and she was frightfully pleased with herself about it. Now, there is no other constraint. The Commons cannot reject its own dissolution. The jurisdiction of the courts is ousted. The monarch, whose prerogative the statute purports to restore, certainly cannot dissolve Parliament, not even in our most recent absurd circumstances. Only the Prime Minister, or the expiry of 5 years, can negative the results of the previous general election. All those millions of votes cast bin at the behest of one office holder. Indeed, we have reached the absurdity that during the time when the Conservative Party were choosing Liz Truss to be the leader of the party, Boris Johnson remained Prime Minister, and in law, he and he alone could have asked for a dissolution. Commons, where the PM has a comfortable majority, rapidly, as it habitually does unless parliamentary time is becoming constrained, rejected a Lord's amendment which would have tempered this modern manifestation of the prerogative and required a majority, a bare majority in the Commons to support its dissolution. Today's Prime Minister can more or less echo King Charles I, that parliaments are altogether in my power for their dissolution. In the available time, I want to touch briefly on 2 further important Stuart prerogatives, which are now vested directly or indirectly in the Prime Minister. In passing, though, I want to highlight the penetrating foresight of Sir John Eliot with the 1625 Parliament identified the danger of what he thought of as the democratic process then, of course it wasn't, but that's how he thought of it, of leaving the control of business in one person. Today, that powerful weapon in the Commons is in the hands of the government of the day. Eliot, too, ended up in the Tower, and sadly he died there. First elections. Charles I exercised the prerogative to control membership of the Commons. Simple. He did it to appoint those who were frustrating him in Parliament to become high sheriffs of their counties. And in those days, a high sheriff could not, in any circumstances, leave his county. So they couldn't go to London, so they couldn't be members of Parliament. Among the names to conjure with them then are Cook, Phillips, Alford, and Wentworth. Don't worry about them, they're names that are now history, but they do matter. And then the honours system, King James I created 600 knights within 3 months of his arrival. Francis Bacon, a great man, but very vain, like lots of people are, described the title as almost prostituted. Nevertheless, he wanted one for himself. But then, having got it, he expressed the hope that his own personal dubbing should not be merely gregarious in a troop. I love it. More important, as a precaution against the Lords supporting the highly significant petition of right, although he had a very powerful majority in the Lords, in April and May 1628, Charles packed the Lords, much smaller then than it is now, with 6 new peers. I've really worked at this. I've tried to find any mark of distinction in any one of the 6 of them. This is the best I can do for them. One was a nephew by marriage of the king's favourite, the Duke of Buckingham. One was a favourite of the new Queen, and one bought a viscountcy, no less, for a donation of £20,000, a vast sum to the cash-strapped king. I'd love to tell you I'm making it up, but I'm not. That's what happened. Nothing changes, does it? Except this. We'll come to it in a moment. The Prime Minister makes peers. So 2 aspects of the prerogative. One already constitutes, forgive me, one already constantly misused by prime ministers from both sides. There is an appointments commission, but it cannot look into the suitability or justification for appointment of any candidate identified by the prime minister. Only their probity. The House of Lords, which is desperate to reduce its size to sensible proportions, has no voice. No one and nothing has any controlling influence over the prime minister. That prerogative still thrives 400 years on. As to elections, a bit more subtle that. The Elections Act 2022 has granted the party in power what I regard, and some do, but not everybody does, as a significant measure of control over the Electoral Commission. The primary justification, the requirement for this influential body in a modern democracy is absolute political neutrality, a perception of political neutrality, and an actual independence of political influence. Despite Lord's amendments, again, rapidly rejected by the Commons, that independent body must, not may, must now have regard to guidance from the Secretary of State. Guidance is a newish phenomenon, legislation disguised by an emollient word. The result is a diminution in the independence of the Electoral Commission, leaving the Prime Minister directly appointing members of the legislature to one house, influencing the elections to the other house, and solely responsible for dissolving Parliament. That's not a bad hand. The Stuarts might not have thrown it away either. I must move beyond prerogative powers. Given the way musical chairs has recently been played with the identity of the resident of number 10 Downing Street, what I'm about to say may seem a little audacious. What I have said about the Prime Minister and the Commons may seem a little audacious. But although Prime Ministers come and go, the office itself is untouched. We have become habituated, in John Locke's penetrating phrase, to the transfer of lawmaking powers from the legislature to the executive, and worse, for the executive to approach its own responsibilities on the basis that a majority in the Commons enables it to do anything and everything. I'm not making any comment about Trussonomics, but those wide-ranging economic proposals were agreed by the Prime Minister and the Chancellor of the Exchequer and proclaimed to the nation before they were seen even by the Cabinet. Astonishing, but commonplace. Policy proclamations that should first be made to Parliament are now frequently first made to the media. That doesn't suggest respect for the House of Commons or the House of Lords. So I'm back where I began, proclamations. There never was any constitutional objection to the King issuing proclamations which advertised existing law or even that encouraged agreeable behavior. You really shouldn't be shouting out in the middle of the streets at 12 o'clock at night. Okay, who minds a proclamation to that effect? There is none today, no objection to that sort of deal with the public. What the Commons asserted in 1610 was an indubitable, could somebody use that word again, indubitable right not to be subject to proclamations which enforced compliance with new law created by the palace, by the King. They were following well understood constitutional principles. Today, there are many rhetorical flourishes in the House of Lords about Henry VIII clauses in legislation, referring to the notorious Act of Proclamations 1539, but even that notorious statute had its limitations and was repealed immediately on Henry's death. That actually was no more than confirming a provision at the bottom of the Act there to be seen that the Act should not survive Henry's death. Stephen Gardiner, I can't remember whether he was in favor or not at that particular time in Henry VIII's reign, but he was there at the time, observed that nothing in the Act enabled anything to be done contrary to an Act of Parliament or common law. And I'm going to tell you this because in 1555, you'll see why in a moment, the judges in Mary's reign asserted that, quoting, no proclamation by itself may make a law which was not law before, but they can only confirm and ratify an old law and not change it. The reason for mentioning it is that the Oracle of English legal history, Sir John Baker, who's I'm privileged to be talking to on these issues today, draws attention to the observation in the report, which every single one of you who's practiced at the bar will be familiar with. The note says that although there were some contrary precedents quoted, the justices had no regard for them. Oh dear, think of the times you've all made submissions when the judges have not really wanted to pay attention to what you have to say. So, in 1610, there was already long-standing and national antipathy to lawmaking by proclamations. The abolition of the Star Chamber in 1641, which was the enforcement authority, effectively ended the practice of lawmaking proclamations. But our Constitution evolves. The objectives of unacceptable Stuart proclamations are now achieved by delegated legislation. Now is not the time to address the way in which emergency measures required by COVID were put through Parliament or not put through Parliament or didn't go to Parliament till long after they'd been in fact come into force. There was said to be an emergency. Can we just forget that? Because we mustn't fool ourselves that this use of statutory instruments, there were 500 or so of them, was either a new or a temporary phenomenon or confined to emergency situations. Largely, statutory instruments are not dealing with emergencies at all. Largely, they are new laws which adjust and govern our day-to-day lives. In 2022, our increased expectation of what central government and local authorities and quangos should provide, and indeed the myriad of societal issues which require legislation, has the consequence that some secondary legislation is necessary and often appropriate. Now, in theory, that's all under parliamentary control. First, the powers are enacted by Parliament. Second, there are, I think, 16 different ways in which parliamentary control over statutory instruments may be exercised. Well, hooray. What am I fussing about? I mean, what could be better than that sort of way of Parliament controlling statutory instruments. The reality. I venture to suggest that this reality would have been regarded by our ancestors in the 1620s as government by proclamation. Why? Well, the powers are gifted usually in skeleton acts. Legislation which declares a policy. Hooray, we all in favor of good high academic standards, says the school bills. We all are. But is there a word about academic standards in the bill? Not a word. There are 18, I think it was A to T, but it may have been new ways in which the Secretary of State could, by regulation, decide what academic standards should be. All left to statutory instruments. It's a complete assumption of authority by the executive. There's even a Henry VIII clause as clause 3, allowing amendment by secondary legislation even before the required academic standards have themselves been defined in a statute. Today, when an Act of Parliament omits a Henry VIII clause, you can be sure it is only because someone in the department has failed to press the relevant button on the computer, and he or she will get a bollocking for having done so. And there'll be an attempt to amend at second, third reading to put it in. How strange it is, isn't it, that delegated legislation has become this strange creature. But I haven't dealt with the parliamentary control. The constitutional theory is that the exercise of these lawmaking powers, the Secretary of State with his 18, I forgot to say only examples, that's just examples in 18, so it could do more. Well, it's subject to parliamentary control, but in reality there is none. No draft statutory instrument can be amended. If there are 99 perfectly sensible clauses, but one which is outrageous, you can't just chuck out the one. You have to chuck out all 100 of them. The executive controls business in the Commons, that danger identified by Eliot 400 years ago. For what whips perceived to be indiscipline, the penalty is service on the Commons delegated legislation committees. And the consideration given to the secondary legislation is absolutely minimal. I've derived these facts from a lot of information given to me by the Hansard Society, I'm sorry. Since the 1980s, many thousands of statutory instruments prepared by government powers, the government departments, have created powers granted to ministers, including the creation of criminal offences, including offences punishable with imprisonment, have been before and accepted by the Commons. As a for instance, between 2005 and 2009, over 6,000 statutory instruments were laid. I haven't counted the pages, but I'm realistically assured that in every single one of those years, between 11,000 and 13,000 pages of statutory instruments, over 50,000 pages of statutory instruments produced law. In the session before COVID, so forget about the COVID crisis, 2017 to 2019, 2,323 statutory instruments were laid before the Commons. I think that's mind-boggling. And even more boggling, shattering. Since 1979, that is well over 40 years, the Commons has not rejected a single statutory instrument. How can that be if there is parliamentary control? How can that be? Since 1950, the Lords has rejected 6, the last in 2015. This so shocked the Prime Minister that he set up an immediate review, the object of which was to curtail the power of the Lords over statutory instruments because we were interfering with what the Commons had decided. As though the democratic process could be subverted by a bunch of old Lords, and some young ones too, who in 6 occasions in 70 years or so have said, no, we don't think that statutory instrument is a good idea. For many years now, concerns have been expressed by committees of both houses and many others, not least John Baker himself. Assurances are offered. Oh yes, thank you so much, we will pay attention to it. But executives, nowhere in the world, executives do not really enthuse about reductions to their power. law of nature. Cincinnatus, I think, was the last chap who actually gave up power. But in November 2021, the Secondary Legislation Scrutiny of the Lords, and the chair of that committee is here, published a report under this chilling headline, Government by Diktat, a call to return power to Parliament. That title says it all. I hope you've all read it. Your ancestors who were members of the Inns of Court in 1620 undoubtedly would have done. It was intended, says the report, to issue a stark warning that the balance of power between Parliament and government has for some time been shifting away from Parliament. A critical moment has now been reached when that balance must be reset. At the same time, the Delegated Powers and Regulatory Reform Committee published its own report, equally chillingly entitled, Democracy Denied? The Urgent Need to Rebalance Power Between Parliament and the Executive. And in summary, that records the abuse of delegated powers is in effect an abuse of Parliament and an abuse of democracy. Now, the members of these committees are not Guy Fawkes, you know. They believe deeply in the constitutional arrangements which we have reached. They believe in parliamentary government. Their deep concern is the constitutional arrangements. Their membership is cross-party, includes crossbenchers. Their membership produces unanimous reports. Does the government of the day take any notice? No. These reports were ignored. They weren't ignored in the sense that there wasn't a formal response saying, oh, thank you very much, full of very good ideas, we'll look into it. But in reality, they have been ignored. If it had attended to them, the devastating criticism of the flawed constitutionality of the Northern Ireland Protocol Bill as it is going through the House now has just been criticised by the Secondary Legislation Scrutiny Committee as stark a transfer of power from Parliament to the Executive as we have seen. The bill is unprecedented in its cavalier treatment of Parliament. Such a criticism could not have been made if government of the day had actually paid the slightest attention. I've suggested you should read those reports. It was presumptuous of me to do so. I know many of you are very busy, have very busy practicing lives. When the Hansard Society has concluded its review of delegated legislation, please study it. Do, if you can find time, study these reports that I referred to from the Lords. They matter hugely, but in their tone, and of course in a widely different historical context, these reports represent the petition of grievances and the protestation which James I had to face in the 1620s. Government by proclamation has returned insidiously, in disguise. But that has happened. And if it continues, apart from a requirement for a general election at least every 5 years, a provision which of course is open to amendment by Parliament, it will be Thomas Hobbes, not John Locke, who will have triumphed. And that would be catastrophic. Thank you.
Well, it would just happen that my microphone seems to be switched off. Can you hear me? Yes. Good. We have a little time for questions from the hall. We have roving microphones. And so can we start with the gentleman with his hand there, please?
Good evening, an excellent lecture, and certainly one at a point that's very much worth making. In Hobbes's time, of course, the modern conception of a liberal democracy might have been seen as somewhat far-fetched and was far in the future. But now, of course, it is known that there is not a choice merely between anarchy and tyranny. There is an alternative in the center that doesn't require that. Is it not time to recognize that the same is true for the current arrangements? That it is not either democracy in the form that we now have it, which is in reality, as you described, very much on the path to disguised tyranny, or anarchy, but that there is another way of doing things, and that what is required, because of course the executive has no incentive whatsoever to take any notice, no matter how well made the point is. What is required is for constitutional reform, drastic, permanent, irreversible constitutional reform, radically to dissipate the power of the executive in a way that is completely incapable of being reversed. To be the #1 item on the political agenda, things like total separation of the powers between executive and legislature. You can't have the same person in the same political party in both ever. Directly elected cabinet, so you don't have one appointing the other. You can't control the Commons by controlling political movements. Any constitutional change requiring a supermajority to referendum. Delegated.
But do you mind if we don't have a constitutional instrument? I've got the point.
Yes.
I agree with you this far because the whole purpose of this talk has been to highlight where we've got to. But I, first of all, take the view that our constitutional arrangements properly applied actually can work perfectly well. Okay, you can twist a little here and bend a little there, but basically, if we allowed the Commons more time, if the House of Commons, for example, the members didn't spend much of their time at the requirement of their constituents to be in their constituencies, acting as part of the social services, but actually sat down and read every piece of legislation and thought about it. And if they were prepared occasionally to say to the government of the day, the majority, no, we don't like this, we think the Lord's Amendment's sensible, I think the Constitution as it stands has plenty of opportunity to put itself right. But what you're up against, whether in trying to get it put itself right, or alternatively propose that we should legislate about it, is there's no way a government with a majority is going to say yes to legislative reform which deprives it of power. And as I regard that as never going to happen, I don't see it ever happening. Well, I just don't see it happening. We've got to do it within ourselves. We have to raise, if you like, awareness of what lies ahead. We have to make sure that the prime ministers and the ministers understand that the country doesn't like this. What worries me is that me talking, okay, and I'm assuming everybody here is on my side about this, okay, very dangerous assumption, particularly for a lot of lawyers here. But I read of a poll 3 weeks ago where the people being polled were aged between 18 and 44. And 6 out of 10 of them agreed with the proposition that the Prime Minister should have more power. I'm not speaking verbatim, that what was needed was less parliamentary control. So what you're up against, if that poll is anything to go by, and I don't attach much weight to polls, is that we're also living in a society, we're living in a century where actually talking about liberties and so on, everyone wants to be able to speak freely. Nearly everybody wants to be able to speak freely. They want to walk the streets safely at night. They want to be able to look after their families, all the sort of ordinary things. But we do make huge demands of our governments these days. We expect the government to provide everything. You turn up I never listen to the Today program, it's depressing. But there's always someone on it saying the government should do something about something. And one of the things that Hobbes had in mind, though it's a long time since I read it, what a nerd. I read the Leviathan, my God. I deserve to become a lawyer. He had in mind that the more you demand of your government, the more power it will say it needs, and the more power it may well need. So what you're up against is a combination of circumstances, which, though I entirely agree with you on the general, I can't possibly agree with you is going to happen unless you, want something done about it. Next question, please. Down here.
Thank you, Lord Judge. You didn't mention the European Union. I used to sit on the committee of the House of Commons that considered the avalanche of legislation coming from Brussels. And those of us sitting on that committee were all wasting our time.
Yes.
Because there was no way we could amend or reject that legislation. There was nothing we could do about it. Well, there was. The only thing we could do about it was Brexit.
Yes, I deliberately didn't mention the EU for one reason, because in the context of what I'm talking about, part of our problem, I mean, the mitigation, see, if I were prosecuting, the mitigation would be that part of the trouble is the Commons has got used to looking at statutory instruments, i.e. material coming from the EU, isn't allowed to comment on them. They become law automatically. And so although they go through the Commons, they're part of a process which simply means they don't stop there. And that has contributed, I think, say the sentences coming down from 5 years to 3, that has contributed to the fact the Commons now doesn't bother with delegated legislation and statutory instruments. But you made a fair point. But if I went into EU and Brexit, I'm afraid it would be a different talk and I'd have nobody here. There was a young man behind you, I think. Oh, what's the two behind you?
Thank you. I have a comment and a question, if I may.
Yeah.
The comment is based on your comments on the poll made, and I do wonder whether the poll in relation to younger people wanting politicians to have more power has anything to do with the stalemate that's been experienced over the last 10 years, and whether there is a naivety in thinking that if a politician has a great deal of power in their hands, they can exercise it more freely. And to quote Thomas Hobbes, that would make life not be nasty, brutish and short, as I think was his justification for his view. The question I had was on your thoughts on orders in council, because those are another form of legislation which of course bypass the parliamentary procedure altogether. And I just wondered what your thoughts were on those in relation to what you think as bypassing Parliament, particularly in light of your view on statutory instruments.
Well, as to your first point, I don't know why that poll produced that answer. I'm hoping it was a rogue poll. But of course, everything that has happened in their lives to them that they have seen and observed impacts. And I'm absolutely sure that you're right that what has happened in the last few years, I suspect what's happened in the last few months, it's a poll, quite a recent poll, will have had a huge impact on them. I don't think that the public is sufficiently well aware, and I don't think the media makes any attempt to do it, of the reality. I mean, the figures that I gave you today are straight, they're straight figures. Not a single Commons rejection of a statutory instrument since 1979. So I can't really speculate any deeper than that, other than making that huge generalization that we don't know why people think what they do, and everybody who wants to talk about it has a view about what reason it is why they do, and I don't go along with that line. I think lots of different people think lots of different, many of the same things for lots of different reasons. I'm not going to draw a conclusion for you. As to orders in council, well, I'm not going to, I don't want to start on them. You're making the same point. It's lack of control. But the orders in council aren't quite in the dimensions of the day-to-day lives of the citizens, or most of the citizens of this country. But the point is still the same. It is very serious executive power. I don't think I can embellish that. Next. The gentleman here, 3 or 4 rows back. Oh. I think I should tell you that I recognize Professor Hazel, and I think I should tell you that I spent some time reading a book which was kindly sent to me pre-publication about the prerogative, and I think I should tell you it was a rattling good yarn. Well, not quite a rattling good yarn, Robert, but I really enjoyed it, and I was very grateful to you for letting me see it.
That's very kind of you. Thank you. Can I say, and you may share this as a fellow bencher of this inn, I've long felt uncomfortable about the array of stewards in the portraits on the wall behind you, but it's very fitting in the light of your introduction to tonight's.
But we have put James I outside there.
Yes, that they are, there they all are, staring down at us over your shoulder. To my question, it'll be very brief. You mentioned in the middle of your talk the untrammeled power of the Prime Minister to appoint members of the House of Lords with no limit on their number or their quality. You also mentioned the House of Lords Appointments Commission as the only regulatory body, but with very weak powers. What power would you like to see given to the House of Lords Appointments Commission as a remedy?
The problem with the solution that is constantly put forward is that the great thing about the House of Lords Appointment Commission is it's totally politically neutral. You can almost see the appointments to it. They're made by the Prime Minister. And the Prime Minister's in power. He'll appoint 2 or 3 members of the committee who are on his side, and who may be less inclined to query the people that he or she puts forward for appointment. I mean, the great thing about HOLAC is it is politically neutral. But there should be, I don't know, do we set up a body of the great and the good? I personally think that we should try and take that prerogative power away from the Prime Minister. I think that it should be rested in a committee of probably the House of Commons with members of the House of Lords. And they should be able to look into suitability or the justification. The £20,000 from Charles I, I mean, that's not a justification for making somebody a member of the House of Lords. Not sure that the Queen's favourite is either. But we've got to curb that prerogative. I mean, just think about it. Labour have a much smaller number of peers in the Lords than the Conservatives. They've got fewer of them are across benches. There is, shall we put, at least an outside chance that Labour will be the majority in the House of Commons after the next election. To get to be equal in numbers with the Conservatives, they need about 120. But a House of Lords consisting of nearly 1,000 people is completely balmy. So what would be better would be a system in which the number, we've tried hard to persuade prime ministers to agree to a reduction. There would be a number that was reduced on the understanding that for every 2 who leave, only 1 may be appointed. But you could do it another way. You could have a number of people made to retire after a certain age. I'm 81, so 89 is a good age. Or perhaps better, after serving in the House for so many years, or a system by which you appoint people to the Lords but don't appoint them all to members of the legislature. There are different ways of looking at it, but I think that we can't transmit HOLAC as it currently stands into the vetting body, because that would immediately disturb the way in which it's appointed. I haven't got an answer, Robert. If I had an answer, I'd give you one and you put in your book. But those are the sort of problems we have to face. But it is daft that we have so many peers. They're all able to vote. I mean, a lot of them don't come at all, but they're all able to vote if they wish to. And when the hereditaries were largely got rid of, we still had 92, the people who had titles coming down from the reign of, well, not many from Henry VIII, but quite a few from Charles' time, they're peers, but they don't take part in Parliament. May we have a system in which to recognise high service to the Prime Minister of the day, you can be made a peer but not allowed to vote. But if you've done good service to the community, then you may. There are lots of different ways of looking at the problem, but if I tried to answer any further, it would take up all evening. But it is a jolly good book that you've produced. I can see a hand raised at the very back. Is your hand raised at the back? Yes.
Lord Judge, thank you in particular for the range of topics which you introduced this evening in your talk. Can I return to secondary legislation?
Yes.
And a question without, I hope, a comment, which is this. The volume of secondary legislation to which you referred and the problem of parliamentary scrutiny, what do you see as the solution? Is it more and more detailed primary legislation? Is it making secondary legislation amendable rather than just having power to reject it? Is it not having this legislation at all? And if it is further parliamentary scrutiny of what is currently in the law via secondary legislation, do you think that both houses of parliament will have sufficient time to perform it, given the volume?
That's a fair question. As to the first point is we must not have legislation which is a skeleton bill. That's an insult. We're going to have a skeleton bill to deal with the EU legislation. We've got a skeleton bill going on in the House now, the Northern Ireland Protocol Bill. There's one clause which says this is a jolly good thing, which I don't think should be in legislation at all. I think legislation should be defining the law, not doing party political stuff. Then there are two clauses which directly attack in my view, unlawfully, attack the arrangements that we have with Europe in relation to Northern Ireland. And then the rest of them, I'm not exaggerating, are regulation-making powers. Clause after clause after clause. I don't think we should legislate like that. I think the government of the day must decide what it is that it wants, that it's prepared to put before Parliament for proper scrutiny by both houses. My second would be, I would do away with this, what I regard as the absurd idea that if you lose one part of a piece of secondary legislation, the 1 in the 100 I was talking about, you lose the whole thing. There should be a system by which, if not a single individual member of the House of Commons or the House of Lords saying it, but there really should be an ability to introduce a system saying that if there is opposition to a particular clause in a piece of secondary legislation with such and such a number, then it must be heard and voted on if necessary. Where you would put that number, I don't know, but to stop the idea of messing about with parliamentary time with unnecessary debates and discussions, I would have a minimum number of people who have to indicate that they're unhappy with the particular instrument or the particular part of the particular instrument and do it that way. But those two things, it seems to me, are absolutely essential. Now, I'm so sorry, I can't go through another whole rigmarole because there is a lot more stuff, but those are the two essentials. Never any more skeleton legislation. And make an arrangement, agree an arrangement between the parties about how to get rid of 1 or 2 clauses within secondary legislation without losing the whole part of the instrument. Yes. Please, the gentleman in the second row.
Thank you very much. So thank you very much for your amazing lecture about the parliament legislation and the monarchy and the executive. My question is about the parliament legislation and case laws. So I'm from Japan. So for me, the Japanese court is sticking to the written laws. Our system is continental laws. But when I look at the English laws, the case laws has their own roles to creating the new laws or legislation. So my question is, what's the relationship between the parliament legislation and case laws? So is it still the case law is restricted by the parliament law?
Yes, it's a fair question, and there are 2 aspects to it. One is, no, there is no court case that Parliament cannot overrule. Majority in the Parliament decide what. In the meantime, the courts go on trying to interpret the acts of Parliament. They go on and try and interpret the common law and produce the answer that they think the law requires. That Parliament can always overrule any decision, even of our highest court. As to the subtext, I'm surprised I haven't been asked this question directly. Well, I think I was more or less. What about a written constitution? Constitutions mean what goes on in people's hearts. I've read the Russian constitution. My God, I'm showing off, aren't I? Leviathan, Russian constitution. Well, I might have read both together, mightn't I? But they don't preserve liberties. If the constitution is being subverted by people who don't believe in it, doesn't matter how many times it's written down. The American Constitution is absolutely essential. If people attack the Capitol when the result of their constitutional arrangements produces a president that some of them don't want, that Constitution, well, it's not worth the paper it's written on for that issue. So we need to be very careful about having written constitutions. It isn't the answer. And the other problem with it is we would spend years deciding which bits of the Constitution should go into which parts of our Constitution. In other words, what do we do about, what shall we say? We're doing it now. Demonstrations. I mean, we'll be arguing that and producing a law which will not be liked by a lot of people, whichever way around it is. And I don't think we can legislate for a constitution, a written constitution, because I don't think we want one. I think the public would think it a waste of time. And as I say, even if it were all written down, within constitutions, people grab power. People subvert power. People subvert the defenses. So the answer to your main question is Parliament can always overrule a court. Right, now I've got a question for all of you. Aha, you didn't think that was coming, did you? I'm pointing to my daughter and granddaughter, okay? They're going to have to do this. Not my wife, I wouldn't dare ask Judith to do it. Is it the King, comma, I'm sorry, is it the Prime Minister, comma, in the Commons? Or is it the Prime Minister hyphen, in hyphen, the hyphen Commons? Very big difference between the two. If the comma comes in the wrong place, you're saying the Prime Minister can do what he likes, but must talk to Parliament. If we're talking about hyphens, then the situation is that there's an equilibrium between them in which all influence each other. Now, I want your answers on a piece of paper within 3 minutes from now, please, and please could they be collected there? No. But do please reflect on that. The King in Parliament is what you are all taught, what we all believe. But I don't think, I mean, it's lovely, lovely piece of constitutional history, and we've got there. But we do need to worry about the Prime Minister, comma, in Parliament. James would happily have settled for the King, comma, in Parliament. That's what he thought the constitutional arrangements were. And he, remember, was as near to God as it's possible for a human being to be. Thank you all very much.
Well, there's only one word that really comes to mind, which is stellar. The opportunity we've all had this evening to listen to, and some of us have had to question and advance our thoughts with this evening's speaker, is a great privilege. I hope that it's going to be replicated in further talks by other speakers on behalf of for the Selden Society and the Four Inns, but the bar this evening has been set enormously high, and we're tremendously grateful to Lord Judge for what he's said and done. So thank you again, Igor. Thank you.
Thank you very much.